mention one of the case.
This is not the mention.
Manoj,
This is not the mention time.
Manoj, within the
This is not the mention time. Already.
Your leadership, serial number 30, order complies of withdrawal khatam.
Serial number?
30, contempt 679 of 20. With best efforts of this honorable court, the order has been done.
Payment has been paid. We have also got the affidavit done.
30 consent.
Serial 306.
679. Contempt 679.
Contempt civil 679 of 25. The learned counsel for the petition submits that his reliance has been
Readdressed. They are filing an affidavit. This will
counsel
take.
for the opposite party is present. He files an affidavit which is taken.
Para
In view of
7.
the aforesaid circumstances, this court is not inclined to proceed any further in this petition. The contempt proceedings are provided.
Public.
Also, it is from various item 1, second to 55 of 2003.
Let's meanwhile happen to go through one of the judgments. Well, let's, if your lordship may permit, may I place it? Let's, I'll be taking bit of the court's time to place the judgment.
What is it on?
Well, it's on the restore.
You are giving it to the others?
Yes, ma'am.
What do you want to say by virtue of this?
Well, it's in this particular matter as well, Millets, in the first appeal, what has happened is the appellant died, and Millets, the second appeal was filed without the substitution of the appellants in that matter, Millets, and thereafter in the second appeal, Millets, the applications were filed. The second appeal was dismissed, Millets, and the matter went to the Supreme Court, Millets. Then there, Millets, what has happened is since the applications of substitutions were not entered in at the second appellate stage, it went to the Supreme Court, Millets. There they filed Order 1 Rule 10 application. Supreme Court on Para 6 has said, Millets, the High Court should not have dismissed the second appeal on that ground, and rather it should have entertained all those applications condoning the delay and setting aside abatement, Millets.
No, but here the restoration itself is bad in law.
Well, it's now
Committed fraud, you know.
Well, it's not fraud. He is not alleging fraud on that.
Fraud.
Well, it's in the
You
on
see,
that.
the restoration of the second appeal itself is a matter.
Yes.
Well,
So
it's
that will survive.
well, it's if your lordship, if I accept this that the order passed in restoration was in nullity, well, I shall be restored back to the same position. Well, I was in restoration.
The restoration application will not revive by virtue of my order.
Well,
It's a
then
nullity. You will take steps as per law. We do not know what you will do. This petition for substitution cannot be allowed. You are filing a petition for substitution, not for addition of money.
yes, I am not filing. Well, that was
So
filed
that-
there, and in the
that
interest of
substitution petition cannot be allowed. I am on the substitution.
well, it could not be allowed for the reason that he's alleging that the court the judgment is the order passed by the court is in nullity. Well, I accept this fact that the appellant as well as the respondent number 1 and 5 were not substituted. Therefore, it has been passed against the dead person, and it is non-est. I agree. However, my contention is that in that case, if your lordship treats the order passed in the restoration to be in nullity and non-est, this particular second appeal today on this date does not exist.
Certainly it does not
Yes,
exist.
when it does not exist, I am restored back to the same position as that of I was in the restoration.
No, you are restored back to the same position as if the second appeal stands dismissed.
Then there are 6 respondents, and one.
You see, the sole appellant had expired. Had it been a case where there were other co-appellants, the situation could have been different. But here the sole appellant has expired. That is the position.
In that case, your lordship. But the right to service, in that case, your lordship may keep it tomorrow. I'll assist your lordship on that. But your lordship may.
साहनी आए, आप जाइए मिस्टर साहनी से, उनसे पूछिए क्या करना है। एक केस में उनका ऐसा ही है, you have to you have to take steps for recall of the order in the CMP. By saying that, but you will not be able to say because you were aware that he is dead, but you did not take any steps. वहाँ तो they were not aware that he is dead. यहाँ पे तो वो भी नहीं हो सकता.
And also in the CMP, the petitioner advocate is present and pursue the petition.
Well,
But not disclose that the appellant is
आप आपको जो
dead.
मर्जी हो करिए, आप ऑर्डर सुनिए बस. कुछ नहीं कर सकते. Can't do anything about it.
मतलब इसको कल फर्स्ट केस रख देते मतलब आई कुड
कल फर्स्ट केस क्या करेंगे? ठीक है, कल फर्स्ट केस. ठीक है?
ठीक.
ठीक है. ऐसे नंबर 55 of 2003. कौन सा आइए है?
Minutes IA for IA 5046 is for the substitution of the appellant minutes.
IA number
5060 is for the substitution of the sole appellant.
IA number 5060 of
2024 minutes.
2024 has been filed for substitution of the sole appellant.
Yes.
And IA number
Minutes then it is connected with IA number 8416 which is for the condonation
IA
of the
number 8416 has been filed for condonation of delay in filing the substitution of appellant.
along with setting aside the abatement.
And a prayer has also been made for setting aside abatement.
Yes, minutes.
IA number
Minutes I stand corrected. 8417 it is 8417. Instead of 8416, I wrongly spelled
ठीक है,
because there
8417 check करें.
And 5045 your lordship for substitution of respondent
IA
number 1.
number 5045 of 25 has been filed for substitution of respondent number 1.
Yes, your lordship.
The
When he is not appellant, then there is no right to file
Just a
this,
moment.
any substitution.
Just a moment. The learned counsel for the respondents has opposed the prayer and has submitted that IA for substitution of respondent number 1 cannot be filed unless the substitution of the sole appellant is allowed. Yes, further submitted that the second appeal stood dismissed for default and was restored in CMP number 302 of 2018 by order dated 15/3/2024. And the sole appellant who was the petitioner in CMP had expired on 8/11/2018. And the respondent number 1 in the second appeal in the CMP had also died on 5/7/2020. He submits that the order of restoration of the second appeal passed in CMP is a nullity in the eyes of law in as much as the petitioner in the said case had already expired. He has
And the
also
counsel of
submitted
the-
that.
And the counsel of the
Just a
petition
moment.
not submitted before the
Just a moment. Petitioner of the said case had expired and the respondent number 1 also had expired during the pendency of the CMP. He has also submitted that in the CMP one petition was filed indicating that the sole petitioner has expired, and a petition for condonation of delay was also filed, but the same was dismissed as not pressed. The learned counsel submits that it was within the knowledge. The learned counsel submits that ultimately the appellant of the present case, who was the petitioner in the CMP, was not substituted. He submits that the order of restoration being a nullity, the second appeal does not survive anymore, and therefore the petition seeking substitution of the appellant, which has been filed in this case, is also fit to be dismissed, along with the second. Counsel for the petitioner, appellant, submits that he shall advance his argument tomorrow. सोच के समझ के रेमेडी खोज के आइए. Good पूरा सब्स्टिट्यूशन का जितना जजमेंट से सब बैठ के पढ़ना पड़ेगा।
इसमें तो committed fraud with the court.
देखिए
ये सबमिट नहीं किया
fraud
ना.
is a very strong word.
Yes, that is.
ऐसा नहीं fraud.
हाँ, लेकिन नेग्लिजेंसी तो है
आप
इसमें.
हमको एक बात बता दीजिए, अपीलांट को नहीं सब्स्टिट्यूट करके इनको क्या फायदा होने वाला था कि इन्होंने फ्रॉड करी है?
नेग्लिजेंसी
They are
तो
not-
एटलीस्ट नेग्लिजेंसी
ग्रॉस नेग्लिजेंस,
ग्रॉस नेग्लिजेंसी.
इसमें कोई डाउट नहीं।
और ये अपील है, सेकंड अपील इज 2003, ट्वाइस डिसमिस पर डिफॉल्ट.
कल कितना बजे करेंगे? कल हम लोग कोई रखे हैं क्या मैटर?
Your Lordship, at 1 p.m.
1
to
at 1.
This case from supplementary list. Second item is 6. Second appeal is 3 of 2023.
मैंने पूरा बंद कराया होगा।
But I would like to submit more information.
From the records, I find that only one of the sisters had executed the cancellation. Correct?
Yes. But
No. कुछ चीजें मैंने ऑब्जर्व कर रहे हैं. I will, मतलब will have you. अभी तो आपको सुनना है.
That is
दूसरा
correct.
चीज, that's correct. The other sisters have supported the case.
one or two sisters have supported, and one has supported me also.
So there are conflicting.
Conflicting. But the things
नहीं
which I
आप
wanted-
मेरी पूरी बात सुनो.
हाँ,
I have a right of audience क्योंकि ये सारी ये facts बहुत
now
ज़्यादा.
I have given these facts in the written argument. My lord, may kindly see my
You
written.
must have. On the date of execution of the gift deeds,
Man.
none of the sons were born.
On the date of the gift deed.
No, not, sorry. On the date of coming into force of 1956 Act, none of the sons were born. Correct?
Yes. They were born after 1956.
Yes. Gift deed से age पता चला.
1972.
सबसे eldest son का जन्म 1960 का.
But where they were all minor.
They
They
were
were,
all-
they were, they were.
Minor नहीं, I am talking about a fixed date. 1956 Act
What?
is the material date.
No. I thought that my lord is asking that at the time of execution of gift, at the time of execution.
They were all minors.
They were all minors, but my lord were born.
Born after 1956.
Yes.
Correct? Except one, that is Sandhya Rani Ghosh, who was born on 8/1/1956.
1950.
1956,
Yes.
As per
which is prior to coming into force of the 1956.
Anyway, 56.
Prior to 1956.
yes.
Prior to the material date is coming into force of the Act of 1926.
That I will verify.
I have verified it. आपको दिखाते हैं
It is
document.
on
Like,
record.
it's on
But
record.
the dates of the daughters.
Only one daughter there, so it is 8/1/1956.
Elder daughter.
Yes.
On what date?
It is there.
Is it?
It is marked as exhibit also.
It is exhibited.
Yes.
This document, Mr. Sharma, have a look at it.
The date is 8 of January, 8 of
Specific
January.
date is there.
Yes.
Jharkhand Academic Council का certificate.
But
Pleading भी है और finding.
हम इसमें दूसरी चीज देख रहे थे. Hindu Succession Act is been. It has come on the 17th June.
17/6/19.
17
But what will have to take into consideration? The area is Rajma.
देखिए वो सब कहानी हम इसमें
हाँ.
सुनेंगे. I will not listen to all that because that is not a substantial question.
Anyway,
We are only concerned with the succession under the Hindu Succession Act or under the Mitakshara.
yes.
By virtue of birth of this daughter in the family prior to coming into force of Hindu Succession Act. My first question to you,
Yes.
what would be the status of the father?
Yes. Since the father was alive of the daughter born on this 8 January 1956, the property remained with him. Had he died before 1950,
Had remained with him as what? His personal property
yes, he
or
uh,
ancestral property?
no, as his, it will be considered as his self-acquired separate property, because when he inherited the property in 1934 after the death of his father, there were nobody like the sons were
So
not
according, no, I'm just noting it. According to you, it was his self-acquired property.
yes.
Irrespective of the birth of this daughter prior to coming into force of 1950.
He inherited in 1934.
Maybe, whenever he inherits.
Yes, yes,
You see, a property which he inherits
yes.
may become a part of his co-custody property the moment the children are born in the family.
No, at the time when he inherits the property, he acquires it as his absolute property. I'll come to that. You're
When
also
you say
talking-
that he acquires it as absolute property,
Yes,
and it is neither a co-custody property nor an ancestral property,
yes.
then which is the provision of law in particular you are referring?
This is under the Mitakshara law only.
So
I
for
have
this,
referred
yes,
to the judgment
which
of-
judgment in particular
Yes.
can we tell me?
Yes, yes. I just. This is 2022, volume 11, Supreme Court cases 520. This I have already, your lordship.
Yes, yes, I just want to revisit that.
Yes.
5 to
20, 520.
5.
Yes. From this, I will show that how the property devolves.
Para number? Para number?
Actually, in this case, what had happened, the right of the daughters were discussed. So, in this case, we will see that earlier, prior to the commencement of 1956, the property of a male dying devolved on his male issue only. And thereafter, in the absence of male issue, it will go to widow, and thereafter to the daughters if the male issue is not there and the widow is not there. Firstly to the male issue only, and if he is there, then it will not go to anyone else. Your Lordship, you kindly see page 4 of this judgment.
In the present case, since the succession of the suit property opened in 1967,
Yes.
upon death of K, the 1956 Act shall apply, and therefore the daughters, being a class 1 here, shall also inherit the property. In the present case, in your case,
Yes.
when did the succession open?
First time in 1934,
Right?
and second time in 1992 when Surya Narayan Ghosh died.
No. the succession in your case
Yes.
opened in the year 1954
Yes.
when the original owner of the property died.
Died. Yes. That
Then
was
the
his self.
property remained with his son throughout.
Yes. Throughout. Yes.
throughout.
Yes.
He acquired by inheritance.
Yes.
Right? Now, before coming into force of 1956 Act,
Yes.
a daughter was born in the family.
Yes.
Does she have a right of maintenance
Uh, yes, that is there.
from the property?
Yes.
So does it acquire the status of a joint family property?
A joint family, your lordship, when he inherited the property, like that time there was no joint
That's
family
right.
existing.
But the moment the daughter is born in the family,
Yes.
does the nature of property converts into a joint family?
After the
Birth of
birth
the
of the daughter. We'll have to see the definition of joint family then, your lordship. So I'll come to that.
And
Yes.
if the property gets converted into joint family property prior to coming into force of the 1956 Act, then under such circumstances, upon birth of more children in the family, the status of the property continues to be a joint family.
I would like to make one submission in this case, your lordship. Then there
I'm
has to
making
be.
my thought clear
Yes,
after
yes, yes, I'm
hearing-
understanding.
Yes.
Your lordship, in that case, if there was a joint family existing, there is no pleading with regard to that. When did the joint family came into existence? Whether
The joint, you see, we are seeing the facts on the face of it, admitted
Yes.
facts on record.
yes,
There is nothing, these are absolutely admitted. Because first question is whether it is an ancestral property.
yes.
That
Yes,
is the
only
first
the
question.
first question. Yes.
Right? They say it is an admitted fact that it is an ancestral property.
Yes.
Right? So there was no difficulty in the court to come to that point. Now the point is that if this is a joint family property and it devolves from the grandfather, then under such circumstances it acquires the status of ancestral.
No, your lordship, for a moment.
It is not an ancestral property according
No,
to
no, no. To qualify as ancestral property, it has to be inherited by three.
To qualify as co-personal property, it has to be in. But all ancestral properties are not co-personal
No,
property.
they are not. They are not.
But
Co-pass-
still,
Yes.
it is a joint family property and it is an ancestral property. Ancestral property is much wider than a co-personal. So, it is an ancestral property. Now the point is whether it is a co-personal or not, that is not the substantial question of law.
That is not the
My substantial question of law is whether it is an ancestral property.
property. Yes.
Correct?
Yes.
So if it acquires the status of an ancestral property, then on this property, the children born prior to 1956, they have a right over it. They are not deprived. And if any property is gifted, to deprive one of them, then will that gift be null and void?
First, we'll have to see that whether it was a joint family and whether he was competent to execute the gift deed or not, despite the fact that the daughter was born on 8 January 1956, your lordship. First, we'll have to see just because
That's
the
right.
daughter had the right to maintenance, will that make the family a joint family? Because the father will have to look after the daughter. So that doesn't make the family a joint family. Because in this case, the father will have to look after the daughter, Your Lordship. That will not make the family joint family. Joint family means other members of the family staying together and having a common, even a common kitchen and common property. That will make the property.
Father with children does not constitute a joint family amongst them.
Father with the children. Like only I think when they get married and all, and they are staying and
ऐसा
have
तो concept
sons.
नहीं है।
We'll have to see the definition of joint
ये
family
कुछ
property.
basic facts थे जो मैंने point out किए हैं। अब आप हमको अपना written submission से total trace करना है।
Written submissions have been clear. My lord was pointing out those things I have given in the written submissions.
Can you place it? You just read it.
But before that,
Your
I
Lordship,
would like
before he starts one submission, because there is judgments of Supreme Court that unless there is specific pleading with regard to the fact that when it came into existence, whether the joint family was existing or not, that will have to be seen.
You see, they say that it is an admission that it is an ancestral property. This is what they say.
But we'll have to see to it because the trial court below has not answered this question. Like she had filed the suit seeking declaration of the property as ancestral property. The trial court considered it as ancestral property, but we'll have to see that according to law whether it is ancestral property or not.
That's
That is what.
we'll see
As
that.
per law, yes.
We'll see that.
Yes.
As per law, we will see.
Yes.
Your Lordship, yesterday, my lord, I had argued, my lord, that my lord, what is the issue, important of issue? And my lord, when an issue, my lord, is required to be framed, on that point, Your Lordship, I am relying on 2009 AIR.
Where have you mentioned it in your written submission?
Yes, I have mentioned.
कहाँ
You, my lord,
जहाँ पे
just-
mention किए
हम
जहाँ
खाली-
mention किए उसको
इसको खाली
बताइए।
देख लिया है।
हम देखते हैं उसको भी देखते
देते हैं।
हैं। क्योंकि हम I'll pick it up from the written submissions.
Yes,
That is.
yes.
हाँ बताइए।
मैं बता देता हूँ। Para 21 Your Lordship, may kindly see. With regard to first substantial question,
Para 21
money, did my lord find
and
whether courts below erred in recording a finding about the nature of the property as the ancestral property? आपको मैंने copy दिया.
yes.
It is submitted from bare perusal of the plaint, as well as the written statement. It would appear that the parties contested on pretext itself that the property is ancestral property. There was no specific denial in the written statement regarding the nature of the property, and there was no occasion for the manor trial court to frame any issue with regard to this. Order 14 Rule 1 CPC contemplates that issues arises where the material proposition of fact or law is affirmed by one and denied by the other. As there was no denial and the parties contested the suit in the backdrop that the property is ancestral, question is ancestral, there was no occasion to frame any issue with regard to the nature of the property. In case in hand, it is not in dispute that the property in question was acquired by grandfather, namely Babulal Ghosh, and after his death, his son Suryanarayan Ghosh and his widow. It has also come out that the widow was also alive. She
From
died
where
in,
do I get this? I was not able to get this.
no, it is in the evidence of DW1. Cross-examination, para 37 specifically.
किसका है? किसका है? आपने
DW1, I will show his evidence. Cross-examination, he has admitted that the grandfather,
Who was DW1?
DW1 is the name, Malad. DW1 का क्या नाम बताइए? He is the only Malad defendant who has examined. No, others have not even been examined.
Examine means cross examine.
No, examined also.
तो
He-
कैसे सबका एविडेंस कैसे रिकॉर्ड हुआ?
नहीं, चार ने कंटेस्ट किया जरूर, that has also I have mentioned in the my written argument. लेकिन सिर्फ एक नहीं इसमें गवाही दिया, जैसे विजय कुमार याद.
He is defendant number 4.
One.
Defendant number 4. Defendant number 4 in the suit.
बताओ.
Defendant number 4.
Defendant number 1.
4. No, he is defendant number 4 and examined as DW1.
ठीक ही तो बोल रहे. DW.
कहाँ है बताइए?
देवानंद घोष एलियस यादव. इसका क्रॉस एग्जामिनेशन दिखा दे.
हाँ बताइए कहाँ पर है?
क्रॉस एग्जामिनेशन.
पैरा 15 में आ गया, क्रॉस एकदम मेन चीफ में गया.
हाँ, इसको देखा जाए.
क्रॉस एग्जामिनेशन में कहा
तमाम दिखा दे. सबसे पहले इनका 2-3 चीज हम दिखाएंगे ज़्यादा.
नहीं, आप यही चीज दिखाइए ना, जिस पॉइंट पर है आप उस चीज को दिखाइए. जो ऐसे सब चीज दिखाने से सब गड़बड़ हो जाता है.
हाँ.
आप हमको बताइए कौन सा पैरा नंबर आप बता रहे थे, कौन सा पैरा?
DW1 हम दिखाना चाहते हैं.
अभी आप पैरा नंबर बताए थे, आप बताइए ना.
37.
वही कॉन्स्टेंसी.
Just
मेरी दादी भी
मेरे
जिंदा थी.
दादी जिंदा थी जब उस समय मेरे पिता की उम्र थी. क्या नहीं कर सकते. जो से पहले वाला देखा जाए. इसमें
मेरी दादी भी जिंदा थी.
जी 34 देखा जाए. सन 34 में मेरे दादा सूर्य नारायण घोष बालिग थे या नहीं बता सकता. दादा की मृत्यु हो चुकी थी या दादा किस साल मरे थे नहीं बता सकते. 34 में मेरी दादी जिंदा थी या नहीं बता सकते. मेरी दादी किस साल मरी थी नहीं बता सकते. 36 में मेरी बहन संध्या गांधी का जन्म संध्या रानी घोष का जन्म 56 में हुआ था. वर्ष 56 में ही मेरी दादी जिंदा थी या नहीं बता सकते. मेरे दादा मरे तो वारिस के रूप में मेरे पिता थे. मेरी दादी भी जिंदा थी.
1934 में मेरे पिता सूर्यनारायण घोष बालिग थे. नहीं, मेरे दादा की मृत्यु हो चुकी थी. ये तो बोल रहे हैं पैरा 34 में.
हमारा पैटर्न 37.
पैरा 34 तो पहले
देखो इसके बाद इसमें नीचे में लिखे हैं 34 में मेरे पास शादी हुई थी. नहीं मतलब 34 में भी लिखे कह रहे हैं.
नहीं, मेरे दादा की मृत्यु हो चुकी थी.
मेरे दादा किस साल मरे थे नहीं बता सकते.
किस साल मरे थे नहीं पता, लेकिन 34 में बोल रहे हैं कि मृत्यु हो
साल ही तो है.
चुकी.
34 तो साल ही ना है.
नहीं पैरा 34
हमारा कहना है कि 56 के बाद सबका डेथ हुआ है. लेकिन ये तो खुद पूछ रहे हैं तो बोल रहे हैं कि नहीं हम नहीं बता सकते हैं कौन साल मरे. स्पेसिफिक पूछा गया तो नहीं बता पाए. अच्छा इसके बाद
स्पेसिफिक ईयर नहीं बताया, लेकिन मेरे दादा की
तो
मृत्यु हो चुकी थी ये तो बता.
34 तो ये बोल रहे हैं कि चूंकि 34 ही बोलते आ रहे हैं. लेकिन 34 21 साल मरे थे बोलते कि नहीं 34 में ही मरे थे. साल डेट नहीं बताते जब बात. इसके बाद इसमें हजूर 37 देखा जाए. मेरे दादा मरे तो वारिस के रूप में एक साल मेरे पिता थे. मेरी दादी भी जिंदा थी. इसमें तो इनको नहीं कह सकते हैं कि विडो वाज नॉट अलाइव. विडो वाज आल्सो अलाइव. एक्सक्लूसिव इनका ये कहना है कि हम एक्सक्लूसिव ओनर हो गए, हमको टोटली डिवॉल्व कर गया. कैसे प्रोडक्ट के हिसाब से नहीं. अच्छा उसके बाद जो हुजूर कल पूछ रहे थे कि उस समय जिंदा थी कि नहीं जिस समय एक्सक्लूशन ऑफ डीड हो रहा था. 38 में लिखे हैं, बोले पढ़ देते हैं. जमीन दादाजी खरीद की थी. खतियान में बाबूलाल घोष का नाम है. हमारे दादा की जमीन को ही मेरे पिता ने हम चारों भाइयों को दान पत्र के द्वारा दिया था. 72 में मेरे पिता ने कुल मिलाकर 35 बीघा 19 कट्ठा 1-2 दान किया था. उस समय बहनों का भी जन्म हो चुका.
ये तो इसमें तो कोई डाउट ही नहीं. दान के समय तो बहनों का जन्म हो चुका. कम से कम एक बहन का तो हो ही चुका.
हाँ
वो तो 1956
नहीं दान के समय तो चारों का हो गया था.
दान के समय चारों
चारों का. जिस पॉइंट पर हम जो फोकस कर रहे थे उसको हम पढ़ते हैं.
ठीक.
In case in hand, it is not in dispute that my lord I am reading page 20. Babulal Ghosh, after his death, his son Surya Narayan Ghosh and his widow, who was alive at the time of the death of Babulal Ghosh, inherited the property. After birth of DW1 to 4, they all constituted a co-partnership with their father, as well as daughters, now as per the amendment in section 6 of the Hindu Succession. Honorable Apex Court in the case of Bachaj Nahar versus Nirima Mandal and others, reported in AIR 2009 ARSW 287, has considered the objects of pleading and the importance of framing the issue. Even a case specifically not pleaded can be considered where the pleadings are in substance. In case in hand, parties went to trial fully knowing the rival's case and laid all the evidence not only in support of their contention, but in refutation of those of the other side. It cannot be said that the absence of an issue was fatal to the case or that there was a mysterious which vitiates the position. Reference is invited in this regard to the ratio laid down by the Honorable Apex Court in the judgment reported
That's
in
we have seen it.
AIR 1964 का जजमेंट उसमें
ठीक.
रेफर्ड है, अब अलग से भी देते हैं. इसमें क्लियर है कि इसमें इशू के बाद पॉइंट पर आप सिर्फ इसी पर भी टेक्निकल इशू के पॉइंट पर आप नहीं कर सकते. एंसेस्ट्रल इशू का अगर नहीं भी था तो पार्टी जब गए तो किया ही है, वो तो हो गया फर्स्ट. सेकेंड एस्पेक्ट पर हुजूर हमको बहस किए थे कल. With regard to second substantial question of law, regarding disbelieving of relinquishment deed executed by plaintiff and registered gift deed executed by father in favor of defendant, it is humbly submitted. Section 122 of the Transfer of Property Act contemplates gift is the transfer of executing existing movable or immovable property and made voluntarily and without consideration by one person called a donor to another called a donee and accepted by all on behalf of the donor. Such acceptance must be made or होना चाहिए. Acceptance accepted by all or के जगह और. Such acceptance must be made that such acceptance must be made during the lifetime of the donor, while he was capable of giving. In case in hand, from bare perusal of gift deeds, Exhibit 323 by D, executed by Surya Narayan Ghosh, father of the parties, in favor of defendant number 1 to appellant, herein it would appear that at the time of execution of gift in the year 1972, defendant number 1 to 4 appellants herein were all minor. There is no representation on behalf of the minor and such gifts are not permissible. On perusal of gifts, it would have transpired that there is no acceptance, as the property in question was ancestral. The consent of co-partners was required, which is
नहीं,
also
co-partners क्यों बोल रहे हैं? Consent of all the members of the family, joint family, co-partners आप नहीं use कर सकते हैं. Term at this stage, should I correct it? All members of the family.
to have born and alive at the time of the execution of the gift, but no consent was taken from them as apparent from the gift. It is not in dispute that Surya Narayan Ghosh died in the year 1992, even after lapse of 20 years after the execution of gift, but no such acceptance was made during the lifetime. The entire court, after perusal of gift deeds and settled legal position in this regard, has concluded that gift deeds are ab initio void and not valid in law. Learned First Appellate Court, after perusal of evidence on record, has affirmed the finding and has held that the gift deeds are void ab initio, and on the basis of same, plaintiff and her sisters cannot be deprived of their share in the light of the ratio laid down by the Honorable Apex Court in the case of Vinita Sharma versus Rakesh Sharma. With regard to additional substantial question of law, number 1, framed by the order.
Just a moment. ये कहानी अभी यहाँ खत्म नहीं हुई on void ab initio. Where is your discussion in connection with the relinquishment deed that it is also void?
उस पर भी आ रहा है. All right. That with regard to additional substantial question of law, 1, framed order dated at 18/12/25, it is humbly submitted that the findings with regard to relinquishment deed and gift deed that their award ab initio is in accordance with law does not warrant any interference. Then a trial court, while holding the same as award ab initio document, has elaborate analysis of recital and requirements as completed and has rightly relied upon 1989 Madras 257. I will also rely.
Where is that?
I have here.
Where did you? 1989 Madras. This is one document you have in mind. This is first one. Madras
1989 Madras.
आपके सबमिशन में जो है
हाँ सब
वही
ये सब
जैकसन
सब
में?
सब लिखा हुआ है।
हाँ बट मद्रास में क्या है?
Madras का पारा 38 Before Malad,
Just a moment.
I would like to show law.
Para 38.
Contract. Section 25.
Yes, please. बताइए पढ़िए
Agreement without consideration void unless it is in writing and registered, or it is a promise to contemplate for something done, or it is a promise to pay a debt barred by the limitation. That what is the ratio laid down by the Madras High Court also. It is a fundamental principle of law.
Just a moment. Yes, please.
Law पढ़ेंगे.
ये हम देखें बताइए 38.
It is fundamental principle of law of alienation that when once a partition has taken place in a family and is acted upon, if it is an oral one, thereafter there is no question of any release of any right with respect to that portion of the allotted property can take place, and the property which is allotted to the share of the person in part, or it can only be alienated the way the settlement or any relation known to the transfer of property and not by way of any release or any right in it. When once a partition takes place in a family and there is nothing remaining in the property of the joint family which has been so partitioned and which lies in the hand of the allottee for releasing the right in the share of the property that is allotted in partition. Only if the property which is not capable of being partitioned is held common by the persons who got partitioned as a member of the joint family, there can be a release of interest in the said common property which is not capable of being partitioned, becoming a subject matter of release. In the instant case, there is no such kind of release of interest by any of the shares with respect to the property which was considered invisible in partition. A careful reading of two deeds, which are called as release deeds, clearly shows that the documents are partition deeds, though they have been described in the release deeds by the parties. But in the case in hand, the learned trial court as well as the appellate court has taken note that there is nothing mentioned in the recital that what amount of gold or how much money was paid, etc. And taking that, it has said, no, it is not a release deed, neither a partition deed also. So taking that view of the matter, it has held that it is ab initio matter. I will read from the judgment of the trial court as well as the appellate. My lord, may kindly see further. And has
This argument I am not convinced.
My lord?
I am not convinced with this argument.
No, I will show it. After considering the requirement of the valid gift deed and what gifts as have been supplied. Whether
Yes, please continue.
deliberate analysis with regard to the relinquishment deed and after considering the requirement of the valid deed and what the gift and what an initial document which is in accordance with law and the same does not warrant any interference. Additional substantial question of law framed by order dated 18/2025 whether the challenge of the gift deed and relinquishment deed were barred by limitation. It is humbly submitted that a learned trial court after perusal of records and elaborate analysis has concluded that the gift deed and relinquishment are right word of none. It is well certain the question of limitation will arise only when the documents are valid. A reference is invited in this regard to the judgment reported in 2006 AIR LCW, 2005 SCW 353 Prem Singh. It is humbly submitted that partition suit was instituted in the year 2005, being OS number such and such for partition of 1/8 share of the land. Then the appellate court, after perusal of entire materials, has concluded that suit is for partition and relief for declaration of gift deeds and disputed by her in favor of brothers and subsequent Nadabi Nama by her and her sisters are only consequential reliefs and are not barred by limitation. The first appellate court, while considering gift deeds and relinquishment deeds, has found the same as barred document invalid in law and relying on the ratio laid down by the Honorable Apex Court in Vinita Sarma versus so and so held that the daughters are entitled for their share in the ancestral property which is in accordance with law.
This Nawadi deed is not in relation to the same property which was involved in the gift deed, as argued by you yesterday. Because
That is correct.
it is not with regard to the same property.
It is with regard to the property in question.
That's right.
It is a separate problem.
Separate. That is
It's not the same.
Gift deed, the property involved in gift deed is different from the property involved in the
Relinquishment.
Yes, I agree.
correct?
But gift deed, father has executed gift deed in the favor of the sons in the year 1972. And my lord, Nabadi Nama has been executed by sisters in the year 1994. On the they got it misrepresented, my lord, on that pretext it has been my lord, on the ground that you are basically relinquishing your rights which has, for the land which was gifted by the father. This what is the case?
That is not the relinquishment deed. Relinquishment deed is not in relation to the gifted property.
My lord, may kindly have tried to appreciate what they have done.
You made out a case.
My lord, may I
A case was made out that you were supposed to execute the relinquishment deed only with respect to the gift deed, the property involved in the gift deed, but fraudulently the other property was also taken care of in the relinquishment deed, and the daughters were completely different.
Other property only they got it relinquished.
Yes.
So
Fraudulently they got it
yes,
relinquished.
on the pretext that basically you are relinquishing rights of the land for which the father has disputed it.
That's
That what I
that was the case.
That was the case. So ultimately, my lord, the result is, if your lordship will find result that the 32 bigha which the father got executed the gift, my lord, at the relevant point of time, though they were at present, my lord, no share, and my lord, because of Nabadi Nama, 50 bigha and all also my lord, got relinquished. So ultimately, so far as the daughters are concerned, despite it is an ancestral property, my lord, they did not get anything. Now, my lord, I would like to, my lord, so your lordship may kindly see.
No, you see, now you are saying that plaintiff
The
defendant
one
number one.
or two point I would like to say. Your lordship may kindly see by page 17, page 26, para 17.
26. Parasite.
They had specifically, my lord, after extensive argument, my lord will find that I will read it from the judgment also. Thereafter, my lord, the point of determination was framed by this court, my lord, the appellate court. Whether the suit of the plaintiff is actually a suit for declaration and the reliefs claimed in the suit is hopelessly barred by limitation. Whether the plaintiff and sisters are entitled for the share as decreed by the learned trial court in the property of their father after relinquishing the same validity. These two specific points were framed, and my lord, after perusal and after everything, my lord, the court has come to a finding. No, it is a suit for my lord, partition. You may kindly see those findings. My lord, may kindly see the findings. It is para 9 in the appellate court judgment. My lord, may kindly see the appellate court judgment. Appellate court judgment, your lordship, I would like to see.
Para 19?
Yes, para 9.
Para 9. We have read it yesterday, completely.
Para 9.
Para 9, it's the same thing which you have
Answer,
told.
yes. Then I would like to show the findings. Only two
Now,
paras.
page number 27.
Only two paras I would like to. It is internal highest 27. In the light of the above mentioned discussion and the judgment, did my lord find?
Yes, sir. Para
In the
10.
apex court, and after going through the gift deeds which has been disputed by father of the parties who is the karta, it is clear there is no mention in the gift deed that which pious purpose or legal necessity the ancestral property is being gifted to other properties. The only factor in the gift deed is that the property is being gifted to love and affection and being pleased with the service. Admittedly, at the time of the execution of gift deeds, the sons who were the appellants herein were minor and were also unable to render any service. Then the trial court has rightly held that the gift deeds are void ab initio, and on this count, even if suppose that the minor sons, after attaining the majority, accepted the gift deed and enjoyed the property which is reflected, filed by them. Moreover, as stated above, the gift of the ancestral property is not done for the pious purpose or legal necessity, and it clearly is done without the permission of other co-sharer daughters. Hence, gifts are invalid on this count also, and held by the Supreme Court in the judgment of Thimaiya and others versus the Gama. This judgment I have in my reading notes I have also given. As far as the relinquishment of deed disputed by daughters in the favor of their brothers
The
seems to
reference of Thimaiya is in page number?
my reference.
Yes, no, in the improved judgment.
It is at page 28.
28, I'm just marking it.
It is AIR 2000 Supreme Court 3529.
Page 28 is not, it is at page 29.
20. Internal page. Did my lord find? Yes. May I read further? As regard the relinquishment deed executed by daughters in favor of their brothers seems to deprive their share in the ancestral property, which is not permissible as per the judgment of the Honorable Apex Court. In Vinita Sharma versus Rakesh Sharma Supra, when the deed are invalid or void for any reason, they are not required to be declared void or invalid, and hence, if their validity is challenged at any stage, the challenge of such deed is not barred by limitation. The sum and substance of the judgment of the Honorable Apex Court in the Vinita Sharma versus Rakesh Sharma Supra is that the daughters are co-partners like sons, and their shares in the property cannot be deprived unless prior to 2024 ancestral property is partitioned either way of a decree or by way of a registered partition deed. As any such document which gives the effect of partition depriving the share of daughters in the ancestral property is not valid unless cogent is forwarded by the parties taking benefit of such deed is given and the reason is required to be closely scrutinized by the court. In the present case, the learned court has rightly held that the gift deeds executed by father in favor of son, void ab initio, and subsequent relinquishment deed executed by daughters under the representation of allotting property which are left are execution of the gift deed, but in fact there was no such property left. In the light of the aforesaid discussion, any answer to my point of determination number 1, that the suit for plaintiff is suit for partition, and the relief of declaration of gift and deed disputed by father in favor of her brothers and subsequent Nadabi Nama by her and her sisters are only consequentially and are not barred by limitation. In the light of the judgment passed by the Honorable Supreme Court of India in the Vinita Sharma versus Rakesh Sharma, reported the daughters are entitled to their share in the ancestral property. So, my submission, Your Worship, that it is a suit for partition. That is my first submission. And my lord is also well aware that when in a suit for partition there is no limitation. There is no limitation. So, my lord, if taking, my lord, the case from that view, the limitation part, that is one part. So now the question, Your Lordship, is that if they do these documents, my lord, which are registered, whether are in impediment or not. My Lord may kindly appreciate. The suit was instituted in the year 2005. My Lord, at best, my Lord, so far as the knowledge point your Lordship is regarding the gift deed is concerned, my Lord may say that you had a knowledge of gift in the year 1994. I had yesterday I have shown 109 your Lordship. My Lord will kind that he will my Lord count from 2094, my Lord, 2005 is within time. Within time. That part,
94 is the relinquishment date.
but at the time, that time only at best I can have the knowledge.
Knowledge of what?
Knowledge of gift deed. Gift deed. And that knowledge part you will achieve, though we have said that on production, that we have amended our plan. But even if Malad your Lordship may consider that no, it is 1994 at best you had the knowledge. Then even as per the 100 ratio laid down and limitation 109 article 109, your Lordship it is within 12 years. And so far as your Lordship the relinquishment deed is
Within 12 years from the date of knowledge.
हाँ, हमको जब नॉलेज आएगा तभी ना हम करेंगे. हमको कोई चीज का नॉलेज तब होगा अगर हम उसके बाद भी नहीं किए तब आप कर सकते हैं.
Is it your case anywhere that you have no knowledge?
हम तो हमारा कहना तो यही है हजूर कि हमको इसका जानकारी एक्चुअल में ऑन प्रोडक्शन अगर कोई हमको ये गिफ्ट डेट देंगे तब हम उसको जब हम अमेंडमेंट करके उसको चैलेंज किए. हम तो शुरू में पार्टीशन के लिए सिर्फ फाइल
इसका बात तो है ही, ऐसा तो नहीं है कि आपको नहीं मालूम है कि
नहीं, हमको कब मालूम होगा.
आपने डॉक्यूमेंट नहीं प्रोड्यूस किया है.
नहीं, हम तो इन्हीं का डॉक्यूमेंट को हम एग्जिबिट भी कराए. हम इन्हीं का डॉक्यूमेंट को हम यूज भी किए.
और आपने रिलिंक्विशमेंट डीड में भी गिफ्ट डीड की बात कर रहे हैं.
गिफ्ट डीड का तो वो बात है 94 में है. 94 में ये इसलिए कर रहे हैं जो कि दैट इज द पॉइंट. वो कह रहे हैं ना कि 94 में आपको पिताजी वाला जो जमीन हम लोग कराए हैं सो दे देंगे. तो अगर जब ये बात अगर आया है जैसे अगर नवादी नामा में तो आखिर तो ये पॉइंट पर तो आ गया कि हाँ आपको नॉलेज 94 में हो गया. आप कैंसिल भी कर रहे हैं. नवादी नामा भी आप एक्सिक्यूट किए हैं. तो नवादी नामा एट बेस्ट इसका 94 से पहले इसको नहीं माना जाएगा. और 94 में हमको जब नॉलेज हुआ तो हम विदिन 12 years है. दैट पार्ट हैज बीन टेकन इनटू कंसीडरेशन बाय द लर्नड ट्रायल कोर्ट.
The time from which the period begins is when the alienation takes place. When the alienee take possession of the property.
पोजीशन तो खैर ले ही नहीं सकते हैं जब ये एंसेस्टर प्रॉपर्टी है. और जब ये हुजूर ये क्या नाम है कि ये पोजीशन का बात तो तब उठेगा जब हुजूर क्या नाम है खाली रसीद कटा लेने से तो पोजीशन नहीं होता है. ये रसीद कटाए हैं, मान रहे हैं रसीद इनका नाम से है लेकिन रसीद से क्या होता है. और जब ये जॉइंट फैमिली प्रॉपर्टी है तो इनका पोजीशन मेरा पोजीशन तो जॉइंट है. देयर आर सेवरल जजमेंट्स. My lord is well aware about those judgments. A position of a co-sharer, my lord, is a position of other co-sharer. पोजीशन के पॉइंट पर तो इसमें हो ही नहीं सकता. हाँ, हमारे नॉलेज में जब आया तो ये कहा जा सकता है कि हाँ 94 में आपके नॉलेज में आ गया. तो 94 में नॉलेज में आ गया तो हमको तो हमारे पास डीड भी नहीं था, कुछ भी नहीं था. तो हमको जब भी प्रोड्यूस किए तो हम उसको भी चैलेंज किया. ऐसा भी नहीं कि हमने उसको चैलेंज नहीं किया. और रह गया जहाँ तक कि 1994 का जो कि नवादी नामा का बात उसको हम पढ़ना चाहें. उसको हम पढ़ते
वो कौन से आर्टिकल से गवर्न है
जी.
नवादी नामा
Section
अगर वॉइडेबल होगा तो कौन सा आर्टिकल से गवर्न है. अगर वॉइडेबल होगा तो अगर वॉइड है तब तो कोई बात ही नहीं है. वॉइडेबल होगा तो कौन से सेक्शन से गाइड है.
इसमें भी तो हम तो कल भी बहस किए थे.
कौन सा सेक्शन कौन सा आर्टिकल से गवर्न होगा.
पोजीशन तो देखेंगे.
आर्टिकल कौन से आर्टिकल से गवर्न होगा अगर ये वॉइडेबल होगा.
इसका भी लिमिटेशन जो होगा कि हमारे
तो
समझ से 12 साल
कौन सा आर्टिकल से गवर्न होगा बताइए. लिमिट आप ये तो नहीं बोल सकते हैं कि रेसिड्यूरी से गवर्न होगा.
नहीं कैसे होगा.
वो तो
रेसिड्यूरी तो 3 ही साल.
कौन सा आर्टिकल से गवर्न होगा बताइए.
Your Lordship, if I may
एक
be,
तो जजमेंट हजूर आया है जस्टिस पारदी वाला का. इसको दिखाया जाए.
59 से कवर नहीं
इसको
होगा।
हमने देखा नहीं जजमेंट उसी पर
ये वाला आप ऐसे पूछ जजमेंट तो बहुत सारे हैं।
नहीं इस पर
59
ये स्पेसिफिक जजमेंट है इसलिए हम दे रहे हैं इसको, नहीं तो नहीं देते। ये इशू उठा था इस केस में सेल डीड के बारे में, जो कोर्ट ने कहा कि नहीं ये सीट वार्डेबल सेल डीड है, वार्डेबल सेल डीड के लिए लिमिटेशन पीरियड 12 साल। अगर वार्डेबल भी मानेंगे तो 12 ही, और ये चीज ट्रायल कोर्ट ने कंसिडर किया है माय लॉर्ड। इसका तो लाइफ लॉन्ग फॉर्मूला है, मैं इससे भी इसमें ट्रायल कोर्ट ने इस पॉइंट पर कंसिडरेशन किया है, इसको दिखा दो।
So according to you, Article 65 से कवर।
जब वर्ड हम तो हुजूर कह ही रहे हैं, सुप्रीम कोर्ट भी कह रहे हैं।
नहीं, आप जो कहेंगे वही सुप्रीम कोर्ट कहेंगे। आप इसका
अच्छा।
जब तक वकील साहब नहीं बोलेंगे सुप्रीम कोर्ट भी क्या बोलेगा?
तो वकील साहब तो बहुत कुछ बोलते हैं।
वकील साहब साइटेशन बिना बहस किए कोई ऑर्डर होता है क्या?
हम तो हुजूर अपने समझ से
कोई भी जज हो, you cannot attribute knowledge to the judge.
दैट आई
Right? Everything is to be argued.
दैट आई
तो आप जो बोलेंगे वो सुप्रीम कोर्ट ने बोल दिया है, इसमें ठीक है।
नहीं ऐसा थोड़ा होता है। हम जो बोलेंगे हुजूर
आप बोल
कैसे
दिए।
हम जो बोलेंगे हुजूर कैसे लिख देंगे इसको?
ठीक है, ऐसे सब जस्ट ऑन अ लाइटर नोट। बताइए।
हम बता
कौन सा पैरा?
जी अच्छा इसका
कौन सा पैराग्राफ? पैरा 31 का।
जी कभी कोई चीज नजर आ जाती है, ये वाला पॉइंट नजर आया था। उन्होंने जजमेंट में कंसिडर किया है अगर 28 देखा जाए महाराष्ट्र भर से
आप पैरा 31 देखिए ना।
31
You see, there are two kinds of nullity which is possible. One is the person says that it was never executed. A dead person has executed a certificate. It's a nullity. उसके लिए कोई limitation नहीं लग सकती. But when a person is alleging nullity with regard to its content, then it will be covered by Article 51. This is what is para 51 is.
may not to be
Because the content of the document, he would say that no, I did not agree for 10 lakhs rupees as consideration, I agreed only for 1 lakh rupees as consideration. Or maybe he will say that I never intended to sell this property, but I intended to sell some other property. Or I never intended to execute any deed in connection with the property covered by the gift deed, but I wanted to do it with respect to the gift deed, but not with respect to the remaining portion. So the allegation is fraudulent in connection with content of the deed, not with the execution of the deed. Then Article 59 will be applied. Simple. बड़ा अच्छा जजमेंट है.
नहीं ठीक है हम इसमें ये कहना चाहते हैं कि हमारा पोजीशन तो डिस्प्यूटेड नहीं है सबसे पहले इसलिए पोजीशन डिस्प्यूटेड नहीं कि जॉइंट फैमिली
एडवर्स पोजीशन आप क्लेम कर रहे हैं.
नहीं हम फैमिली पोजीशन को काम कर रहे हैं
ठीक है, आप पोजीशन में रहिए, इससे क्या लेना देना है?
जी
आप पोजीशन में रहिए, इससे क्या लेना देना है?
नहीं इससे लेना देना होगा.
टाइटल तो आपका खत्म हो गया ना?
नहीं टाइटल तो हमारा खत्म हो ही नहीं सकता है चूंकि एंसेस्टर प्रॉपर्टी.
भाई आपने अगर मान लीजिए एंसेस्टर प्रॉपर्टी में कोई डॉटर्स मिलकर रिलिंक्विशमेंट डीड एग्जीक्यूट कर दे
लेकिन
तो उनका
सवाल
टाइटल खत्म होगा कि नहीं होगा?
मेरा मेरा हजूर इसमें ये कहना होगा कि अगर कोई रिलिंक्विशमेंट डीड एग्जीक्यूट होता है सब कुछ तो उसमें डोमिनेंट इनका 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 है।
इतना दूर तक हम लोग का
नहीं
substantial
नहीं
question
हम
answer
और
नहीं
भी है हम इसमें
You are alleging fraud in connection with the content of the statement.
मलॉट में कांडे
The content of the relinquishment.
मलॉट में कांडे
And two of your sisters, they rather supported the case.
तो उसमें तो आया है पॉइंट नवादी दवा में आया है
तो फिर
नवादी दवा में ये बात आया है कि लोग का भी कंसेंट है उसमें
सबका
नहीं
consent.
उसका कंसेंट है उसका जो कैंसिलेशन वाला
Consent कोई भाई cancellation ऐसे दूसरा power of attorney लेके cancellation किए हैं.
दो सिस्टर्स वेयर समवेयर एल्स ऐसा आया है
ऐसा कैसे हो सकता है? How is it possible?
इसमें
And
दो
rather, not only that, they were not a party to the deed of cancellation. They have supported the case of the.
My lord, may I appreciate two things. First thing I would like to say.
अच्छा ठीक है हम देखेंगे.
नहीं, ठीक है.
बताइए आगे आप.
हम बता रहे हैं. हम इसमें ये करना चाहते हैं कि सबसे पहले तो इसमें हजूर ये देखा जाए कि ट्रायल कोर्ट या एपिलेट कोर्ट ने इसको क्यों इसको वॉइड एबेनिशन माना. इसको तो कम से कम देखें. ये तो आपका सब्सटेंशियल क्वेश्चन हम लोगों का सब्सटेंशियल क्वेश्चन. इसको देखा जाए. हाँ. विवादक संख्या 9.
कौन सा? एपिलेट कोर्ट का पेंडिंग. एपिलेट कोर्ट
का तो हम दिखा दिए. उसको भी हम दिखाते हैं. इसको पहले हम ट्रायल कोर्ट
इसका स्पेसिफिक इसका दिखाइए कि क्यों इस डॉक्यूमेंट को
हाँ,
वॉइड एबेनिशन माना.
हाँ, ये बता.
वही दिखाइए. Why this document has been
हाँ
treated
हाँ
as void?
वही हम दिखाए. वही दिखाए. मलॉट में काइंडली सिमिलर. इसमें हजूर इंटरनल पेज 25 पढ़ा जाए.
इंटरनल पेज एपिलेट कोर्ट का 25
नहीं इसका ट्रायल कोर्ट का.
आप एपिलेट कोर्ट का फाइंडिंग दिखाइए ना.
अच्छा पहले ट्रायल कोर्ट हम दिखाना चाहते हैं.
कोई बात नहीं.
ज्यादा एलेबोरेट है उसी को हम किया है. और ट्रायल कोर्ट का देख लेते हैं. इंटरनल पेज 25 खाली थोड़ा ज्यादा नहीं दिखाएं. थोड़ा सा इसमें हजूर ऊपर से हम थोड़ा सा 2-4 लाइन पढ़ते हैं. परदस 3 पीछे से पढ़ रहे हैं. तो पारा 24 से
इंटरनल पेज
24 का पीछे से हम पढ़ते हैं. परदस 3 पंजीकृत नवादी नामा की सचिव प्रतिलिपि है. डिड माय लॉर्ड फाइंड. इसमें लेखकारी संध्या रानी घोष, स्वामी निमाई चंद घोष, जाति ग्वाला, पेशा शाकिन, राजमहल थाना सब रजिस्ट्री ऑफिस राजमहल साहबगंज, शांति घोष.
नहीं ये कौन सा पेज 24?
पेज 24 ऑफ द इंटरनल पेज 24 ऑफ द ट्रायल कोर्ट
जजमेंट. लाइन नंबर अराउंड
लास्ट लाइन से पढ़ रहे हैं. परदस 3 पंजीकृत नवादी नाम.
ब्रदर्स.
हाँ. श्रीमती शांति घोष, स्वामी सत्यन सर, लेखकारी विजय कुमार यादव, देवानंद यादव, पिता अमित सूर्यनारायण घोष, जाति ग्वाला, गृहस्थी साकिब राजमहल थाना सब रजिस्ट्री, नवादी नवादी दलील मौजा अलीबाग, नवधारा, फतेहगंज, कासिम सज्जन सच की इतना धूल जमीन है. इसकी अंतर वस्तु में वर्णित है कि हम लोग प्रकाश करता हूँ, आप लोग लेखागारीगण हम लोग के सहदोरे भाई होते हैं तथा हम लोग का मित्र दादा बाबूलाल घोष और मित्र पिता सूर्यनारायण घोष का नाम तथा पैतृक संपत्ति जो कुछ जमीन वास्तुबाड़ी आदि पोखरा बगान जमीन धानी इत्यादि संपत्ति का हम लोग आप लोग से पहले पा चुकी और अब अवशिष्ट जमीन जो जगह धानी बाड़ी वास्तु पक्का मकान आदि पोखर बगान आदि जमीन का जो ऊपर का चौहदी लिखा हुआ है संपत्ति मवाजी 50 बीघा 15 कट्ठा 19 धूर 1/4 जमीन स्थावर अस्थावर संपत्ति है वह कुल आप लोगों का हक प्राप्त अंश संपत्ति है जो कि आप लोगों चारों भाई के बहुत दखल कर रहे हैं वो बहुत दखल बराबर करते हुए आप लोग आ रहे हैं उस उल्लिखित संपत्ति में आप लोगों का कुछ हक नहीं है वो हम लोगों का कुछ हक नहीं है वो आप लोगों का अंश एवं हक प्राप्ति संपत्ति केवल मात्र कागज में हम लोगों का मित्र दादा बाबूलाल गोप और मित्र पिता सूर्यनारायण घोष का आच्छादित है इसमें कोई समय लोग बैरी के बाद पढ़कर झगड़ा विवाद सृष्टि करे व उल्लिखित संपत्ति के बारे में आप लोगों को शांति दो हम लोग को भी अशांति भाव हो या कुल विवाद में मुक्त पाने कर करूं जैसे हम लोग संपत्ति के बारे में आप लोगों को अशांति नहीं दूं हम लोग अशांति
फाइंडिंग पढ़िए ना क्या
पढ़ रहे
ये पूरा 4 पन्ना का रिसाइटल ही है
रिसाइटल
हाँ तो आप फाइंडिंग पढ़िए
अच्छा अब उसके बाद हम अंतर वस्तु लास्ट पर इसको देखा मित्र बाबूलाल पिता सूर्यनारायण घोष प्रत्येक संपत्ति
पेज
का
नंबर 26 पेज नंबर
26 पा चुकी हूँ लेकिन इस विलेख में यह वर्णित नहीं है कि पूर्व में अपना बाप दादा की पैतृक संपत्ति में कौन सा संपत्ति पाई जिससे कि यह विलेख बंटवारा का रूप ले सके तथा इस विलेख में वर्णित 50 बीघा इतना धूर जमीन कुल जमीन आप लोगों के हक का संपत्ति है जो आप लोग चार भाई प्रकट कर रहे हैं उस उल्लिखित संपत्ति में हम लोगों का कोई हक नहीं है वो आप लोगों का हक का संपत्ति है जब लेखाकारी वादी एवं बहनों का उस विलेख संपत्ति में कोई अंश ही नहीं तो वह इन संपत्तियों का अपना हित लेखाकारी के पक्ष में कैसे छोड़ सकते इस विलेख की अंतर वस्तु से स्पष्ट है कि लेखाकारी को यह जानकारी नहीं है कि इस विलेख संपत्ति में इनका कोई अंश है या नहीं इसलिए विलेख स्वयं में ही शून्य दस्तावेज प्रदत्त 3/1 नाबादी नामा का रहितकरण मूल पंजीकृत विलेख है इसमें शांति घोष श्री धनंजय घोष सत्यन सच का रहितीकरण विदित हो कि मेरे पिताजी सूर्यनारायण घोष 72 में मेरे सहोदर भाई सत्यन सच को घोष का देहांत 72 में देहांत हो गया तो मेरे सहोदर भाई ने मुझे मेरी 2 बहनों को कहा कि तुम पिताजी द्वारा दिए गए दान पत्र का जमीन पर तुम लोग अपना सहोदरगण भाई बहन मिलकर नाबादी लिख दो क्योंकि पिताजी का दिया हुआ जमीन है हम लोग दादा के नाम की जमीन है इसके लिए पोतियों का हक हम बहनों ने सोचा कि भाई बहन का बात सत्य है पिताजी जब उन स्वेच्छा से जमीन दान किया है तो हम बहन भी पिता की मृत आत्मा की संतुष्टि के लिए नाबादी लिखना के लिए तैयार हो गई हम लोगों ने भाई ने कहा कि पिताजी के द्वारा तुम जमीनों का नाबादी लिख दोगे तो हम बहन जन सदा रानी शांति घोष
ये एग्जिबिट नंबर कितना है
कौन
ये रिलिंक्विशमेंट डीड क्योंकि इसमें लग रहा है कि एविडेंस के साथ साथ जो है ना रिसाइटल भी घुसा दिया
4D I think it's 4D
एविडेंस के साथ साथ रिसाइटल ओरल एविडेंस के साथ साथ रिसाइटल
ऐसा ओरल एविडेंस आया
ओरल एविडेंस से नहीं चलेगा ना ये तो रिसाइटल लिखा है एग्जिबिट
4D
ये तो कैंसिलेशन डीड का पढ़ रहे हैं
कैंसिलेशन डीड से क्यों पढ़ रहे हैं
राहतीकरण भी किए और
कहाँ से आप ये सब कैंसिलेशन डीड से पढ़ रहे हैं
हम तो इनका
नहीं आपको जो पढ़ना है जो रेलेवेंट एग्जिबिट है उससे
रेलेवेंट ही पढ़ रहे हैं
नहीं हमको आपके ये डिस्कशन ऑफ एक सेंटेंस 3 पेज में चलेगा तो हमसे हमको
हम तो रेलेवेंट पढ़ लेते
नहीं आप डीड से पढ़िए डीड से पढ़िए कि हमको नहीं पता है कि हम कौन सा संपत्ति छोड़
हैं हम गिफ्ट से पढ़ लेते हैं
एग्जिबिट नंबर
4D
4D
वो करेक्टली इंटरप्रेटेड है इसमें कोई गलती नहीं
exhibit D. So it is written such a way, there is codex D.
पेज 7 देखा जाएगा एग्जिबिट 3 का। हम लोग प्रकाश करता हूं कि आप लोग लेखाकारी या सहोदर भाई होते हैं। मित्र दादा बाबूलाल गौड़ को मृत पिता सूर्यनारायण घोष का नाम वैदिक संपत्ति में जो कुछ जमीन जस्तु गाड़ी आदि पोखरा सचल सब कुछ आप लोग से पहले पा चुके हैं और अवशिष्ट के जमीन के जगह धानी बाड़ी वास्तु पक्का मकान बुखार आदि का धानी का जमीन का चौहदी जो है लिखा हुआ जमीन 50 बीघा 15 कट्ठा 19 धुर कुल संपत्ति जगह स्थावर पा चुकी है। वह कुल आप लोग का हक प्राप्त कर संपत्ति है जो आप लोग भाई भोग दखल कर रहे हैं, वो बराबर भोग दखल करते हुए आप आ रहे हैं। उस संपत्ति के में हम लोगों का कुछ भी नहीं है, वह मात्र आप लोगों का अंश हक संपत्ति में है। केवल मात्र कागज में हम लोगों का मित्र दादा बाबूलाल गौड़ मित्र पिता सूर्यनारायण घोष का नाम चलित है, इसलिए कोई समय आप लोग को बैरी बात से पढ़कर झगड़ा विवाद करे वो नहीं। अभी लिखित समिति के बारे में आप लोगों का अशांति हो दूं और आप लोग भी अशांति हो करूँ कुछ विवाद में मुक्त करने के कारण, जैसे कि हम लोग उस विवाद के बारे में आप लोगों का अशांति नहीं हो और हम लोग भी अशांति भोग नहीं करूँ। इसलिए ऊपर लिखित संपत्ति से संपूर्ण रूप से हम लोगों को निस्वस्त होकर उस 50 बीघा 15 कट्ठा 19 धुर मकान पोखर आदि स्थावर संपत्ति का नबादीनामा दाखिल हम लोगों को लिख दिया। यह नबादीनामा आप लोगों को लिख दिया। करार करता हूँ कि लिखित संपत्ति आप लोगों का हक अंश का संपत्ति है, आप लोग दखल करते हुए आ रहे हैं। हम लोग यह नबादीनामा दलील के जरिए जमींदारी सरिस्ता में प्रचलित नाम कटाकर उस जगह अपना नाम जारी करें लेंगे। अपना बाल बच्चों के साथ उस कुल वारिसान के साथ पुष्ट दखल करते रहेंगे। उसमें हम लोगों का कि आप लोगों का कोई वारिसान कोई हक नहीं है।
कहीं लिखा है कि हमको नहीं मालूम है कि हमको क्या मिला है?
तो पढ़ तो रहे
नहीं, कहाँ लिखा है कि हमको नहीं मालूम है कि हमको क्या मिला है? जो आपके इंप्यूट ऑर्डर में लिख दिया है ट्रायल कि हमको नहीं मालूम है कि हमको क्या मिला है, इसीलिए इट इज नल एंड वॉइड। पूरा तो पढ़ लिए, कहीं भी लिखा
तो दिखा।
बस आपका हो गया और बाकी है आपका हो गया, यही लास्ट पॉइंट है।
लिखे हैं तो ऐसा नहीं है कि नहीं है। पा चुकी है लिखे हैं,
बात चुकी है लिखी है, लेकिन
क्या
ये
पा
कहाँ
चुकी है?
लिखी है कि हमको नहीं पता है कि क्या
नहीं,
पा
हमको अभी तो लिख रहे हैं कि हम सब पा चुके हैं।
चुकी
क्या पा
है?
चुके हैं? अगर
नहीं, क्या पा चुकी है वो नहीं लिखा है, उसमें साइलेंट है।
यही
लेकिन ऐसा डीड में नहीं लिखा है कि हमको नहीं मालूम है कि हम क्या पा चुके हैं।
वही कोर्ट ने कहा है कि आपको क्या पा चुके हैं। जब आपको इसमें नहीं लिखे हैं
तो void हो जाएगा।
तो तब रिलीज डेट के लाइट पे नई पार्टीशन के तौर पर आएगा। और क्या रिलीज की, क्या हम रिलिंक्विश कर रहे हैं वो आप
वो तो नहीं, वो तो दिया मैं 50 बीघा 19 धूर जो अभी आप पढ़े।
ये लिखे कि हमारा उसमें कोई हक हकीयत नहीं है।
हाँ तो बस
नहीं तो क्या चीज पा चुके हैं उसके बाद
उसको उसको एवर्स में क्या पास चुके हैं, इट इज नॉट रेलेवेंट.
No, it is relevant. It is as per
एक
the
second.
1989 laws, it is
Mr.
relevant.
Sharma, please hold on. If there are two persons, if there are two co-owners of the property,
But
and if a person wants to relinquish the deed, it is not necessary to say that and in lieu of that what he has received.
my lord, may
It
kindly.
is not necessary.
No, my lord, may kindly appreciate. Section
I will
25.
appreciate by the
Section
writing the
25 of the Contract Act very categorically says that what is a release deed and my lord, when and in what can be released. Learned trial court, my lord, has relying upon the Thamaiya judgment, my lord, appellate court also has said that they have not mentioned what sona, what chandi, nothing.
सोना चांदी का तो बात नहीं लिखा
नहीं
है.
उसमें वो भी आया
रिलीज डीड में नहीं लिखा है.
इनका इसमें रिटर्न स्टेटमेंट्स वगैरह में आया है.
रिलीज डीड में नहीं लिखा है.
हम इसमें दिखा दें.
उसमें रिलीज डीड में लिखा ही नहीं है तो कहाँ से?
नहीं, रिलीज डेट में हम बोल रहे हैं, हम पा चुके हैं, वही हम कह रहे हैं, लेकिन उसमें एज पर द लॉ के हिसाब से इनको इसमें लिखना चाहिए था कि आपको क्या क्या हम पा चुके हैं, तब ना उसके एवज मान लीजिए हम इसमें ये बोलना चाहते हैं.
Just tell me one thing. You are challenging the release deed
My lord,
on the
may kindly
basis of its content.
My lord, may kindly appreciate. अगर कोई चीज हम रिलीज कर रहे हैं, सपोज ये कहा कि अगर ये चीज लिखा हुआ है इसमें कि हम सब कुछ पा चुके हैं, इसके एवज में हम रिलीज कर रहे हैं, रिलीज का मतलब क्या?
You see, what was the ground of challenge to the release deed?
रिलीज डीड
The ground of challenge was कि गिफ्ट डीड का प्रॉपर्टी छोड़कर बाकी प्रॉपर्टी हमसे रिलीज करा ले. यही ग्राउंड है आपका.
इनका हमारा कहना ये है, हमारा ग्राउंड ये है सूट में हजूर कि हमको ये रिलीज ही कह के कराए कि दादाजी का प्रॉपर्टी पोती को मिल जाए. और बेसिकली आप जो रिलीज कर रहे हैं या जो कुछ भी आपको आप दावीनामा जो लिख रहे हैं वो उस प्रॉपर्टी के लिए लिख रहे हैं जो पिताजी का प्रॉपर्टी है,
जो गिफ्ट डीड में से
पिताजी का जो गिफ्ट चारों भाइयों को होगा. लेकिन ये तो बेसिकली तो अपरेंट है हुजूर, ये तो इसमें उतना देखने की जरूरत ही नहीं है. इसमें गिफ्ट भी करा लिए और ये 50 बीघा भी और उसका आधार ये बता रहा है सुप्रीम कोर्ट के जजमेंट के लाइट.
2005 में आपका आंख खुला.
नहीं तो हमारा तो जब भी
आपका आंख 2005 में खुला,
हमारा 5
जब नया एक्ट आ गया.
नहीं तो नया एक्ट का बात नहीं है
नहीं,
इसमें जैसे जब हमको कॉज ऑफ एक्शन मिला, जब हम ही रसीद कटाने के लिए गए, हम ये सब बात इसमें आया है, सब में आया है, जो पूरा रिकॉर्ड में हम पढ़ेंगे तो हम दिखा देंगे. ये सब जब आया जैसे
आप सुन लिए मिस्टर शर्मा, आपको 2-3 दिन से आप क्या सुनेंगे? दिस इज व्हाट एंड यू हैव प्लेस्ड द रिलीज डीड. दैट्स इट. और इसके अलावा
एक जजमेंट और हमको 1976
ये थमैया वाला जजमेंट दिखाइए जिस पे आप बोल रहे हैं कि थमैया वाला जजमेंट में है. व्हाट इज द साइटेशन ऑफ दैट जजमेंट?
हमको लिख के
दिए आप.
ये 2000 सुप्रीम कोर्ट 352 में.
बाकी तो सब आप जजमेंट दे रहे हैं इसलिए पूछ रहे हैं. इसमें
नहीं, ये वाला जजमेंट तो अभी नहीं है, लेकिन हम इसमें लिख के दिए हैं. तो इसमें हमारा रिटन नोट्स में है 2000 सुप्रीम कोर्ट 352 में दिखा दें. इसको मंगा लेते हैं.
ये कोई बात नहीं, आ जाएगा, हम देख लेंगे.
एक तो जजमेंट जो हम दिखाना चाहते थे माय लॉर्ड, ये 1976 का जजमेंट ऑफ सुप्रीम कोर्ट जजमेंट.
देखिए इस तरह से जो आप इस तरह से जजमेंट ऐसे डाले ना यहाँ पर, जो चीज आप प्लेस नहीं किए हैं आपको हम इस तरह से नहीं देखेंगे.
नहीं मतलब प्लेस
सारे जजमेंट सब
नहीं,
प्लेस
सारा
कर
प्लेस
चुके
है.
हैं.
हाँ
75 सुप्रीम कोर्ट ये सब प्लेस किए हैं आप कोर्ट में? नहीं किए, नॉट एट ऑल.
इसमें जो ये जजमेंट एक है इसको देखा जाएगा. पारा 6 इसका 76 1976 वॉल्यूम 1 एससीसी पेज 2 डबल.
जो जजमेंट आप प्लेस नहीं किए हैं
नहीं, वो उसमें है लिस्ट में.
हम उसको अभी क्रॉस कर देंगे. आई विल क्रॉस इट राइट अवे. जो चीज प्लेस नहीं किए हैं उसको यहाँ पे लिस्ट में बनाने से क्या करें? उसका क्या पर्पस है? बताइए 76 में क्या प्लेस करना चाहते हैं?
इसमें
दीजिए जजमेंट दीजिए.
76 में
वेरी सर जजमेंट
76 में हम एक लाइन खाली पढ़ पाए.
कहाँ है जजमेंट?
para 6 देखा जाए.
Para 6.
It is well settled rule of interpretation of dates of release. Page 303 पर.
Yes, sir.
However, wide and general the covenant of release may be, its operation must be restricted to the rights which are in the contemplation or in controversy between the parties and would not cover or comprehend rights which were never in the minds of the parties at that time. हमको रिलिंक्विशमेंट आप करा लेने से मेरा राइट खत्म नहीं होगा. रिलिंक्विशमेंट हमको करा लेने से भी मेरा राइट खत्म नहीं होगा. और इसको हम इस दो प्रोटेक्स्ट में हुजूर को देखना चाहिए. इसमें हमारा ख्याल यही होगा सोल्यूशन. पहला कि ये एक सूट फॉर पार्टीशन है और दूसरा कि विनीता शर्मा का जो केस है उसमें ऑनरेबल एपेक्स कोर्ट ने भी कहा है कि इस तरह का अगर कोई डॉक्यूमेंट से अगर कोई राइट है ब्रीच होता है या कोई राइट अगर इसमें अगर डिप्राइव नहीं करता उसको कोर्ट एग्जामिन करे. और कोर्ट ने लर्नेड अपीलेट कोर्ट ने स्पेसिफिकली ये इशू फ्रेम किया और उन्होंने ये होल्ड किया कि नहीं ये सूट फॉर पार्टीशन है और इसमें ये सब कॉन्सिक्वेंशियल रिलीफ है. इसके चलते इसको हम राइट देंगे. है ना. यही हमारा है.
Apart from the properties covered by the gift deed and this relinquishment deed, there is no other property.
My instruction is that
Complete property हो गया ना?
सब प्रॉपर्टी ही टोटल.
हो गया? अब you what do you have to respond, madam?
Your Lordship, to the question that there was no occasion for the courts below to frame issue with regard to the ancestral property because the parties had admitted that it was an ancestral property. But with all due respect to the courts, Your Lordship, the pleadings were there before the court. In the pleadings, it was submitted that the property is of the grandfather Babulal and it was his self-acquired property. So, the pleadings, all the facts were there. So, it was the court ought to have framed that issue, which it did not. It just considered it as ancestral property. Then I'll come to this point for which I had referred to this judgment. Just now I had given the citation 2022-11 Supreme Court cases 520.
Yes, what do you want to place from here?
From here, I'd like to show that how it would not be an ancestral property.
You have
the
recorded it in your written note also, no?
Yes, but in detail, if you
That's it. Okay, but it is
a little
recorded
bit.
like that, no?
Yes, it is not an ancestral. I have referred to this judgment. It is a extensively surveyed law, and everything is clarified in this judgment.
Yes.
So in this case, it is held that in the absence of male member, only the property devolves upon widow and thereafter to daughter. Like my learned friend had said that the grandmother was surviving, but here before 1956, Surya Narayan Bose was there, so the property devolved upon him as absolute property.
To the exclusion of the widow.
Yes, to the exclusion. It is there in the judgment.
Show me please. Where it
Yes,
is.
page 4. Lordship, we come to page 4 and come to that. A little bit from there it can be seen. The law. Oh, sorry, not page 4. It's 523.
Give me the para number.
It's actually the head notes and the commentaries thereafter. 523. I'll come to that
I don't
also.
have the page number over
Page
there.
para 57. Then it also may come to para 57.
There is no para 57 of this document.
Yes.
There is no para. AIR, this one. This is Sukhbiri Devi.
This is this is Arunachal Gounder. For that I had referred for relinquishment that it needed to be set aside. Arunachal Gounder.
Para number?
We will also come to para number 57.
Yes.
Yes, I'll just come. The principle of law which can be deduced from reading of the aforesaid judgment can be summarized as under. The law laid that in Katama Nachir versus Raja of Sivaganga that succession in the case of Hindu male dying interstate is to be governed by inheritance rather than survivorship is reaffirmed. In the absence of male member, the property devolves upon widow and thereafter to daughter. So it's only in the absence of male member. If the male member is there, it will devolve upon the male member. And in this case, the daughter was there only. So the property, the father died in the year 1949. So the property devolved on the daughter, and thereafter she died in 1967. So in this case, the Succession Act 1956 came, and thereafter it was governed by that, and the properties went back to the legal heir as classified under Section 15 of that Act. 1956, it is there, Your Lordship, from para 69 onwards. If Your Lordship wants, I will read it out. What I want to show from this, Your Lordship, that the daughter inherited the property as absolute property. She became the absolute owner of the property like the son. So uniformity was there. It was brought after Amendment Act, Succession Amendment Act 1929. The daughters were also included under that. Para 68 onwards and thereafter 55, if Your Lordship may kindly note it down that it will be relevant for appreciating the case. 69 onwards.
This was under Hindu Succession Act, or it was under?
No, the old Vitakshara law also is discussed,
No,
and
on the facts, it
yes.
was under Hindu Succession Act, or it was under prior to Hindu Succession Act?
Yes, I will come to that. Like
Yes,
the
please.
father of the daughter in this case,
When did he die?
he died in 1949. So actually, in that case, on the basis of the pleadings, the court came to the conclusion that he died in 1949, though there was submission that he died after 1956, but that is over. So in 1949, he died, the father. So the property devolved upon the...
You read para 6 of the judgment.
Yes. It is an undisputed fact between the parties that the property in question, that is the suit property, was independently purchased by Marappa Gounder in the year 1938. In this case also, Your Lordship, the property was self-acquired property of Babular through the process of a court auction, and thus it was his independent property. However, there was an issue between the parties in respect of the date of death of Marappa Gounder. Appellant plaintiff asserted the date of death as 1957, whereas the respondent defendant pleaded the date of death as 1949. The trial court, after considering the evidence brought on record of the case by the
You
parties,
read para 10.
yes. the learned counsel for the appellant submits that since the property was purchased through court auction sale by Marappa Gounder on 1938, hence it is the independent property and it was never considered a joint family property as such on death of Marappa Gounder. This property would devolve by succession upon his daughter Kubai Amal, who died in the year 1967. He further submitted that under the law of Mitakshara, the right to inheritance depends upon propinquity, that is proximity of relationship. Since the daughter has closer proximity of relationship, she would inherit the property from the father instead of the father's brothers, son and daughter.
When did the father die? Because the other side
No,
of the
that-
case
the
said
court-
that he died prior to enforcement of Hindu Succession Act. He said that he died in 1967.
No, the daughter died after
Daughter
inheriting the property of her father who died.
She
that
died
is-
in
That is
1967.
decided. That is, there is no dispute with the court has upheld that he died, and that is no dispute with regard to that. The death of the father that he died before 1956.
You para 19. In the backdrop of the above facts, the primary issue.
Yeah, that's fine. The primary issue which arises for our consideration is with respect to the right of the sole daughter to inherit the self-acquired property of her father in the absence of any other legal heir having inheritable rights before the commencement of the Hindu Succession Act 1956, or in other words, whether such suit property will devolve onto the daughter upon the death of her father intestate by inheritance or shall devolve onto father's brother's son by survivorship. So the Supreme Court formulated this question, and
So, in this case, the property of the father was self-acquired. Here, the father is acquiring the property from the grandfather.
no, the father is acquired from his father.
Yes, certainly, he is
Not-
acquiring the property from his father, and in this case,
Yes.
the father himself had a self-acquired property who died prior to coming into force of 1956 Act.
Yes.
And the question was whether the daughter would acquire the property
In
as
the
an
absence-
exclusive property,
in
as
the
an
absence-
absolute property,
In the absence of male member.
in the absence of male member, right?
Yes, yes. So similarly here also Babu Lal in 1934, he was the surviving male, he was the only male member at that time. No other issue, only one son, Surya Narayan. So he also inherited the
What is
property.
the consequence of a child born in the family
Yes.
prior to 1956? That is not the question here. What will happen?
Yes, I'll come to
What
that.
will happen if a child is born in the family, male or female,
Yes.
prior to 1956?
In that case also the property will not go to the daughter.
Whether the property will be an ancestral property for the entire family, or it will be a joint Hindu family
It
property.
will not be an ancestral property. Because for the ancestral property, it has to go down to the three
It is for
generations.
co-custody property, not for ancestral property. Not for ancestral property.
No, Your Lordship, there are so many judgments here
No,
also
so
like that
many.
only
There is a
if it
difference between ancestral property and co-custody property,
yes,
right?
Yes.
For co-custody, these generations are important.
yes,
But when a person acquires property from his father, grandfather, or great-grandfather, the nature of the property is ancestral property.
no, here in this case, Your Lordship, in this case only, the daughter acquired the property as her absolute property and not as ancestral
By
property.
succession, because she was the sole surviving here.
Yes, so here in this case also, Surya Narayan Ghosh
He
was the
acquired
only
the
son.
property on the death of the grandfather as sole surviving here, right? He acquired that property.
As self-
But prior to coming into force of 1956 Act, a daughter was born in the family.
Yes, that
Then
it
what
will,
will be the status of this property?
no, it will constitute a joint family property in that
It
case.
will constitute a joint family property.
Yes.
Therefore, once it is a joint family property, can one person alienate the property?
No, Your Lordship, shall come to that. Firstly, that Surya Narayan Ghosh acquired the property as his own absolute property on the death of his father. Now a daughter was born, and before the
Suppose the
commencement,
son was born, what would have happened?
Your Lordship.
Suppose a son was born.
Yes, after he inherited the property.
Yes,
right?
after he inherited the property, a son is born in the family. What
Yes.
will happen? He will have a share in the property or he will not have a share in the property?
He will have a share in the property, but the father will have the absolute right.
No.
No. Your Lordship may kindly appreciate. No, in this case, Your Lordship may kindly see, in this case also.
The moment a son is born, you see that co-partnery may, the co-partnery property or ancestral property will have people going in and coming in, right?
Yes.
But the moment if he would have disposed of the property on inheritance,
Yes.
simply on inheritance,
Yes.
upon death of the grandfather, then there would have been no problem.
Yes.
But he continued with the property.
Yes, I will come
And
to
in the
that.
meantime, the daughter was born.
Yes.
And then 1956 Act came into being.
Yes.
And subsequently in the year 1972, in the meantime, more daughters were born in the family. And he deprived all the daughters and passed the entire property to the sons
That
by
he
way
can
of
do.
gift.
Yes, that he
So
can.
therefore, this particular property was an ancestral property in the hand of the family, and one person could not have alienated it by gifting it to the co-partner also.
No, Your Lordship may kindly come. That is what in this
Then
case
we will
it is
decide it.
acquired the property. Your Lordship may kindly go through this judgment. The daughter in this case, after the death of father in 1949, she acquired the property and she became the absolute owner of this property, right? Before 1956. Thereafter, she died in 1967. There are other sons and brothers of the father. They were there. So, Your Lordship may kindly go through this judgment. She acquired the property in 1949. She died in 1967. Thereafter, like when she died in 1967, this act came, Succession Act 1956 came. So, thereafter, when she died, this act applied and the property went to the father as per section 15 of this act and not to any other co-partners. So, Your Lordship requires.
I will read it. I'll read judgment full.
My only submission is that, as per this judgment also.
All the judgments I cite,
Yes.
I read it full text with all facts.
Yes. So my only submission is that he acquired the property as a separate property because in this case also that it will descend as a separate property and he acquired like the
So it will
daughters.
descend as a separate property and it will never become a co-partnership
No,
property.
it will after the third generation it will become.
So if it therefore,
Yes.
the moment the next generation is born in the family, it acquires the status of a joint family property.
I will come to that. What I want to
Even
submit
if
that
it is not a co-partnership property.
Your Lordship, even if it is not, I'm coming to that. He acquired my submission, Your Lordship may kindly hear my submission, that he acquired the property as an absolute owner of the property, having all right of self-disposition.
Alienation.
Yes, self-alienation, whatever. This daughter was born. As per my Lordship, it constituted a joint family. But I'll come to a judgment. Your Lordship may kindly see. This is 1954 SCR 243. Page 248 if your Lordship has SCR.
Yes, I'm there.
In the middle, Your Lordship. It was held, therefore, that the father of a joint Hindu family governed by Mithakshara law has full and uncontrollable power of disposition over his self-acquired immovable property, and his male issue could not interfere with these rights in any way.
So if it is self-acquired property, then it's not property.
That is what he acquired that property and it will be considered as self-acquired because he acquired the property as absolute owner of the property. Your Lordship, reading the judgment, this Arunachal Gondar, it will make clear. Actually, it was basically for the woman, but from there we can infer that the son also acquired the property as absolute owner. and after he died in 1992. So the daughter also got the right in respect of other property being class 1 heir, and that is how, because they had right, they relinquished their right in 1994. And to say that they came to know about this gift deed only in 1994 is not correct, because from their evidence only I will show that they were aware of this fact during the lifetime of Surya Narayan Ghosh only.
You see,
Yes.
here is the catch.
Yes.
In page 246, the substantial point that requires consideration in this appeal is whether the properties that the defendant number 1 got under the will of his father.
No, that is in
That
this
may
case.
make a difference.
No.
If the property is given by
In
way of
this
will.
case, no, I am not on that point. I am only on the principle of law. You
Yes,
know, in this
yes,
case,
we are also on the principle of
that
law.
is what in this case.
A person who acquires the property by will of his father, that is his self-acquired property, irrespective of the fact whether any son or daughter or maybe 4 generations are born in the family.
Your Lordship, yeah, I'll come to that. See, if it is by will, in this case, it is also given that if the father says that it will be carried as ancestral property, then it
No,
will
that is irrelevant. Whatever,
That is
if
there,
there is a will, whatever the father says in the will is irrelevant. The point is that when a property is transferred by way of will,
Yes.
then under such circumstances, the person who acquires the property through a will, it is his self-acquired property for all purposes, and it will never acquire the status of a co-custody property.
Yes, but here also.
And this is a situation even under the Hindu Succession Act. It talks about will, but it does not talk about gift.
Yes,
Right? It talks about will, but it does not talk about gift.
yes,
So
but
this identical situation, it is there. If a person is acquiring the property by will, it is a self-acquired property, the matter ends.
no, under the old Hindu law, how the property devolves and whether it becomes the absolute property of the person who inherits it is to be considered. Your Lordship, in this case, as per the judgment of the
I
Honorable
think many
Supreme.
of the judgments of the Supreme Court, either of you have not placed. So I will do my needful.
Yes. Your Lordship, this judgment is very important.
I will
From
consider all the
2000
judgments. Don't
Yes,
worry.
yes, please.
You can never have a defense on that.
Yes. So my only submission is that he acquired the property as his, as an absolute owner, and he had the full disposition. And as far as the knowledge of the gift deed, Your Lordship, I'll come to that. That they had the knowledge during the lifetime of Surya Narayan Ghosh only. I'll come
You
to
see,
that.
if it is a voidable document,
Yeah,
then
yes, yes.
certainly the limitation
Yes,
would
yes.
apply.
Yes.
And if it is not a voidable document, if it is void ab initio,
Yes.
then there is no question of application of any limitation.
Yes.
Be it the this relinquishment deed,
Yes.
or be it the gift.
Gift deed. Yes. So I'll just.
Both the courts have held that they are void ab initio,
But-
and that is why they have said that it is not guided by.
But they on the basis that it is an ancestral property. So whether the Surya Narayan Ghosh had absolute right over the property,
Yes,
that
sir,
has to
that
be seen, Your Lordship. And the date of knowledge of the gift.
ये क्या चीज़ है? किसका? आप लोग का है?
I'm appearing on behalf of the point number 6.
You have anything to say?
I have given the written notes of argument.
Written notes नहीं होता है. If you have to add something to whatever he has argued, you add.
I have to add.
Yes, please add.
Your Lordship, the date of knowledge.
एक
That
लाइन
I've seen.
एक लाइन
From the-
हम कहेंगे इनके लिए कि my lord the Arunachala judgment he is heavily relying. My lord has correctly understood. It is by way of the will the property has been. That is not the case.
Not in this case. It was not by will. In Arunachal, it was not by will.
Self-acquired property.
It was not by
कुछ
will.
मेरे लिए भी तो छोड़ देंगे पढ़ने के लिए. चलिए.
So-
आपको क्या बोलना है?
Your Lordship, the Nadavi-nama by the learned trial court was never cancelled on the ground of fraud or misrepresentation. It was cancelled on the ground that the daughters were never aware of the rights they were actually relinquishing. नदाबीनामा में वर्णित संपत्ति में अपना कोई अंश न होना समझकर निष्पादित किया है. If I have no right in a property, your lordship, what I am actually relinquishing? So it was always cancelled. It was always declared void ab initio and learned trial court, not on the ground that that there was a fraud or misrepresentation. Rather, it was declared void ab initio on the ground that the daughters were never aware of the rights they are actually relinquishing. I have in the notes of arguments, I have given the judgment. Sir has also cited that judgment, 1976 judgment, Raja Gopal Pillai versus Pakayam Amal. Para 6 is of importance.
Yes, case already para 6.
A right which I have never contemplated, which I have never thought of, I am relinquishing it. So what
Specific description of the property is there, that I am relinquishing this my right with respect to this property.
But you should have, but the knowledge of the daughters is that I have no right in that property.
That is the saying.
No.
It has to be inferred. They are saying that now you are the son.
How can I relinquish a right which I have never contemplated? They are saying
That is not the tenor of the statement of the relinquishment deed.
That-
Relinquishment deed gives a specific description of the property that they are relinquishing their right with respect to this property.
the relinquishment deed has a schedule, and the
Not
properties
only the schedule, even
and the
in
properties are
recital
scheduled
it
in
is
it. And
there. Even in the recital it is there.
in the recital, the sisters are saying that we have no right in the scheduled properties. Can relinquishment of property be done without having a right in it?
They are not saying that.
From the recital itself, although learned trial court has never mentioned that it is being declared void ab initio on the ground of fraud and misrepresentation, but the learned trial court must have inferred from it that there must be a fraud or misrepresentation. There must be a confusion कि वो लोग जो relinquish कर रहे हैं वो gift deed का property है, not 35 बीघा gift deed करा लिया and the rest 50 बीघा was relinquished.
You made out a specific case that the relinquishment deed was to be executed only in connection with the properties covered by the gift deed and not in connection with the properties with respect to the rest of the properties. That was your specific case.
I'm also making a case on the basis of the findings of the learned trial court that a person executing a relinquishment deed cannot relinquish it unless and until he is aware of the rights he is actually relinquishing. There is a judgment to that effect in 1976. However wide and however general the words of the document may be, the words of the deed may be, it doesn't mean that all rights are relinquished. Only those rights are relinquished which the parties have contemplated, which the parties have ever thought of. How can I relinquish a right which I have never thought of? And the learned trial court has never declared the relinquishment deed void ab initio on the ground that there is some fraud or misrepresentation. It has always declared it void ab initio on the ground that the daughters were not aware of the rights they have in the relinquished property.
Where is that finding?
On page number 33 in my notes of arguments, internal page number 33, your lordship. कहीं पे भी नहीं लिखा है कि फ्रॉड या मिसरिप्रेजेंटेशन का जिक्र नहीं आया है.
ये 33 तो आपका जजमेंट का.
Internal page number 33 of the learned trial court judgment. पेज नंबर 32 के एकदम लास्ट लाइन से स्टार्ट करते हैं योर लॉर्डशिप. संपत्ति आप लोगों का हक प्राप्त संपत्ति है, उक्त संपत्ति में हम लोगों का कुछ हक नहीं है. इस प्रकार लेखकारी ने नादाबीनामा में वर्णित संपत्ति में अपना कोई अंश न होना समझकर निष्पादित किया है. The understanding of the daughters is that they have no right in the relinquished property, and without a right, what is the value of relinquishment? The 1976 judgment, if your lordship may give 2 minutes, the para 6.
Right. Page 33.
Your lordship, the 1976 judgment, if you may give 2 minutes,
Yes.
just para 6, your lordship. It is well settled rule of interpretation of deeds of release. Specifically, this case is about deed of release. Interpretation of deeds of release, that however wide and general the covenant of release may be, its operation must be restricted to the rights which are in the contemplation or in controversy between the parties, and would not cover or comprehend rights which are never in the minds of the parties at that time. Again, it is one more paragraph is there. It is well settled that general words of release do not mean release of rights other than those then put up, and have to be limited to the circumstances which were in the contemplation of the parties when it was executed. This made the learned trial court come to a conclusion that there must be a confusion in the minds of the sisters. There must be some fraud, misrepresentation, although that has never been made a ground for declaring the deeds void ab initio. The only ground is कि सिस्टर ने ये समझकर निष्पादित किया है कि उनका उक्त प्रॉपर्टी में, शेड्यूल्ड प्रॉपर्टी में कोई हक नहीं है. And a right cannot be relinquished unless I have the knowledge that I have that particular right. Without the knowledge that I have a right itself, there is no point of relinquishing. If I have this paper in my hand, I must have this knowledge that this paper belongs to me, then only I can relinquish it. So there is no point of, the Nadami Nama is void ab initio. And if a document is void ab initio, the Prem Singh versus Birbal judgment I have cited in my notes of arguments. In the gift deeds as well, your lordship, the acceptance has never taken place during the lifetime of the father. It is very clear from the recital of the gift deed itself. Learned trial court has marked it for all the gift deeds separately. सिर्फ एक gift deed के लिए नहीं, चारों gift deed के लिए separately mark किया है कि उक्त दानपत्र में कहीं पे भी दानग्रहीता का स्वीकृति कथन नहीं है. For all the gift deeds, also there was an argument arose, your lordship, that the sons were minor at that point of time when the gift deeds were actually executed. So how can there be a statement of acceptance? The acceptance may be on behalf of a legal guardian, your lordship. Necessity of law has to be fulfilled. Section 122, if it says that there has to be an acceptance, there has to be an acceptance. If the minors can't accept it, if the minors can't sign on the gift.
So do you want to say that there can be no gift executed by a father in favor of his minor son?
It can be. The Supreme Court judgment is there that gift deeds can be executed in favor of a minor. The father executed in favor of a minor, but there has to be a statement of acceptance.
Who would accept it?
Since
She has cited a judgment that when a gift is executed in favor of a minor son, then she has cited a judgment of that effect.
Yes, it must be represented. He must be represented by a legal guardian only for the sake of
You
fulfilling.
see, your statement is not sufficient. Which judgment are you citing for this?
I'm
It has to be represented by a legal guardian, and she
I am
has cited
only-
a judgment to this
I
effect.
am only relying on the necessity of Section 122, the necessary requirements in Section 122.
So so tell me the modus operandi by which a father will give to his minor son.
A legal, he may give an application to the.
So I'm just asking you, do you have any citation on this, or you have to pronounce on this?
I like not specifically to minors, but a gift deed must be accepted during the lifetime of the.
We are talking about a minor. A guardian of a minor is gifting property to his son. He's the natural guardian.
But still, that's the requirements.
Do you want to say that if a natural guardian is gifting the property to a minor, he has to seek permission, and the court and the deputy commissioner will appoint a guardian, and the court will appoint a guardian, and then the gift will be accepted?
Then, Lordship, the necessity of Section 122, the requirements of Section 122, which makes a gift invalid in absence of in absence of acceptance, valid acceptance.
You were not there for a couple of days, I suppose.
I was there.
You were here, no? She has cited as a judgment which you have not distinguished.
that is on.
आपका हो गया, अब बैठ जाइए।
उस judgment.
अरे वो बंदे को बहस करने दीजिए, आप दिमाग खराब कर रहे हो। हाँ बताइए।
The judgment I have cited, Your Lordship.
The judgment you have cited, that is okay. Where is the judgment distinguishing the judgment which she has cited?
I know, Your Lordship, the case is for final disposal, so I can't.
What the representation.
And what do you have to say on the point of limitation so far as this relinquishment deed is concerned?
The relinquishment deed is a void ab initio document. That is what I am saying. For a void
You
ab initio.
see, the judgment which he has cited, इनको दीजिए the judgment you have cited.
कौन सा judgment है?
Live law वाला? Para 31. When the challenge is to the contents of the deed and when the challenge is to the nature of the deed, in both the circumstances, Article 59 will come into play.
Your Lordship.
And on top of this, the deed is not challenged by each one of them. The relinquishment deed is challenged only by one of them. Another one supported, right, the plaintiff, and two supported the defendant.
If the deed is void ab initio, Your Lordship. If
You will not read 31.
I don't have like.
You don't have 31 matches down there.
This in Uni versus Kunchiyamma.
Like para 31.
Again, I think Your Lordship, two copies of that judgment are not available.
When there is a challenge to the contents of the deed, when there is a challenge to the nature of the deed, then Article 59 will come into force. And not 60.
Article 59 of the Limitation Act would find no application to the case in hand.
Naturally, because there, in that case, the deed was, suppose a person says that I have not executed the deed. There is an imposter, right? Or a person was dead on the date when the deed was executed. These are the circumstances where it will be declared null and void. Otherwise, if you want to go to the recital of the deed, the contents of the deed, or title, etc., then under such circumstances, and it is a case where a person who is executing the deed is challenging it. Anyways, we will decide. Anything else you want to
For
say?
rest of the arguments, I adopt the arguments put forward by the rest of the respondents.
What's your name?
Pranjali. Pranjali.
You practice here?
Yes.
I've never seen you. You don't practice in civil law? Oh, very good. इनका नाम लिखिए सब लिखिए आपको एमएलके से अपॉइंट करके ठीक है एटलीस्ट यू अंडरस्टैंड व्हाट इज इट ऑल अबाउट
No, today also he had assisted me in some of
Must.
the
Which college have you passed out from? Which college have you passed out from?
National Law University Ranchi. NUSRL Ranchi.
तब तो पढ़ाते बढ़िया है ना चलिए कंक्लूडेड
Subject to Lordship's kind convenience for that supplementary serial 7 if kindly made if
one was mentioned yesterday where is the council
yes
where is which item
my lord serial 7 supplementary colleges it was mentioned yesterday my lord it is in the list today subject to Lordship's kind convenience it may come tomorrow my lord
yeah I will hear it right away what do you mean tomorrow
no I thought Lordship
चलिए
this case is over.
This case is over. I do not know I will post it for dictation tomorrow or not. I will just decide it tonight. Then you will have the progress. कोर्ट में लिखाना सबसे अच्छा है आपकी जरूरत नहीं होगी आपकी जरूरत नहीं होगी नॉट रिक्वायर्ड बहुत सारे जजमेंट्स आप लोगों ने लेकिन प्लेस नहीं किए
There are number of judgments.
अभी एक उन्होंने मेंशन किया 31 में क्या है बस सब एडमिट करके नोटिस कर दीजिए क्या करना है सब रेगुलर है ना कोई सब रेडी है सब में नोटिस कर सब एडमिट करके नोटिस कर तीनों नोटिस विद इन 15 days speed post right I already processed both आप आइए आपका मैटर
So the issue in the matter is that, my lord, without proper preliminary notification and without following the due procedure of law, my lord, for acquisition, my lord, the land of the petitioner was, my lord, acquired. And
It's a writ petition?
yes, my lord.
No, yesterday one second appeal was mentioned.
No, writ petition was mentioned. It is on the list wide, my lord, bench slip only. Yes.
जो second appeal mention की वो कल की हाँ बताइए क्या बोलना है
But the issue in this writ petition is that, my lord, the land of the petitioner, my lord, without following the due procedure of law, and my lord, without even the preliminary notification, my lord, it was acquired by the respondent authorities, my lord, for my lord, construction of Gumla bypass highway, my lord, and my lord. While this writ petition was pending, it is a 2017 matter, my lord, several orders were passed, and in a hot and haste manner, my lord, the petitioners were dispossessed, and my lord, the construction of the Gumla bypass has started on the land of the petitioner.
Does it belong to you?
My lord, it is clear. Annexure 1 of my main petition, it is clear that this land belongs to
What
me.
is the next one?
It is the one patta through which I have got this land, my lord.
Do you admit that the
It
land
is
belongs to
valid,
you?
yes.
Yes, Your Lordship, it appears, I am for the Union of India, the state land acquisition officer has stated that this land belongs to the petitioner, Your Lordship, and I have filed counter affidavit on 14/11/2025, Your Lordship. The process for the acquisition has been going on, Your Lordship, and 3A process, 3A for the notification is under process, Your Lordship, and now I am going
Under 2013 Act.
My lord.
and now I am going to file another counter affidavit, Your Lordship. From this it appears that the 3A process has already been done, Your Lordship, and for 3D the process is going on.
The
Your
process
Lordship.
is on.
My lord, the proposal of the notification, I am only praying that, my lord, I have filed an IA for, my lord, stay of the construction. So far as, my lord, until the compensation is given to me, the construction may be stayed, my lord. IA has been
Construction
filed.
cannot. These are all public utility.
Lordship, I bow down to that, but only for Lordship will kindly, my
You
lord.
see, at the end of the day, you are going to be dispossessed. You have already been dispossessed.
I have already been disposed.
What will you get by stay of construction?
My lord, at least, my lord, expeditiously, my lord, it's
What
8
is-
years, 13 years old, my lord, acquiring the acquisition proceedings. 8 years old matter, my lord.
They will come.
Today also, my lord, notification, this may be ordered that expeditiously the notification may be published. The draft of the proposal of notification is
She is on the verge of filing a supplementary affidavit.
Yes, Your Lordship.
a date may
She
be
has
fixed.
said that she is on the verge of filing a supplementary affidavit. You will have your all the whatever compensation is
Compensation
there,
is-
there any dispute, everything will be taken care of.
Yes, the compensation also
So
which they are off.
why a project should be stayed?
My lord,
Give
the
me one reason.
the compensation also which they are offering, my lord, it is, I am disputing because,
So you have a remedy to that.
my lord, they are
If
doing
you
it.
are disputing the quantum of compensation, you have a remedy under law that will not lead to a situation that the construction is to be stayed.
Yes, I'll go for my lord. I am only saying that
Yeah, go for
contrary to
it.
the settled principle of law, the Honorable Supreme Court, my lord, in several judgments has said that the compensation has to be decided and the determination of the compensation has to be done, my lord, in the market rate and not the circle rate.
The case here is not for determination of compensation.
Correct.
You have a right to get compensation.
Yes.
You are not in possession of the property. The project is going on, and there are certain notifications which are being issued. Then you will have at best whatever compensation you will get. You will challenge it. You will accept it. You will not accept it. That is absolutely for you. But those steps are required to be taken. How much amount of compensation has been offered to you?
34 lakhs as per
34
circle
lakhs?
rate, yes.
Okay. Have you accepted it? Not
No,
accepted.
not accepted till date.
Okay. You have not even accepted it under protest?
No, I have not protested it because 34 lakh offer was given to me, my lord, on the supplementary counter affidavit was filed on, my lord, 5/1/2026.
That's right.
20 days back, 15
That's
days
right.
back, yes.
So, do you want to accept the offer under protest, or is
Yes.
there no provision
No, no,
for?
no.
You can accept it
I can
under
accept
protest.
it only if your lordship will kindly give me a liberty.
I don't need to give you a liberty.
I will accept this 34 lakhs only if my lord gives a liberty that I can go for arbitration for the disputed
I don't
amount.
need to give you any liberty. The liberty has been given to you by law.
My lord, this may be recorded now.
Why should I record it?
But if I
You
accept
are the
this
counsel of your litigant.
34 lakh rupees, if I accept it, my lord, tomorrow no one will give me, in my limited experience, if I may say this, my lord, if I go for arbitration, my lord, they will say that 34 lakh rupees has been given to you as per circle rate. And it has to be given in market rate in my lord, limited knowledge.
So that is not the issue before the court. You see, there is a timeline to go for arbitration. And you are not doing service to your litigant. Once it is offered and if you don't accept it and if you don't take action within the timeline, then you are in a soup.
So 20 days back I have been offered.
Maybe I do not know what is the timeline.
No, 20 days back only, it is
You do
already.
whatever. You have been offered 34 lakhs.
Mine.
Which is as per affidavit dated 5/1/26.
Yes, as per
You are
their
not going to
affidavit.
stay any kind of construction.
At least expeditiously, my lord, notification may be taken out.
They will do the needful. I do not know what they want to do, and but at least that much is offered to you. You are not in possession of the property. Construction will not be started.
My lord may fix this case for hearing so that, my lord, this may be disposed of as per your lordship's
I
guidance.
number 914 of 2026 and WPC number 2567 of 2017. This petition has been filed seeking an interim relief directing the respondents or their men and agents from carrying out the construction over the land measuring an area of 2.25 acres, which as per the petitioner, the land has been not, the proper procedure for the purposes of acquiring the land has not been followed. During the course of hearing, the learned counsel for the petition has submitted that a meager amount of rupees 34 lakhs has been offered to the petitioner, which is apparent from the affidavit dated 5/1/2026. And admittedly, the petitioner is not in possession with respect to the property involved in this case. The learned counsel for the respondents has submitted that
And
the
for Union of India, Your Lordship, and the state is also the respondent.
learned counsel for the Union of India, Ms. Nikki Sinha, has
Nikki Sinha, Your Lordship.
Sinha has submitted, I never intended.
Yes.
Ms. Nikki Sinha has submitted that she is shortly going to file an affidavit bringing on record further notifications
Yes,
of the Union of India / state government in connection with the property involved in this case.
Yes, Your Lordship.
Considering the aforesaid facts and circumstances, this court is not inclined to stay the ongoing construction over the property. Accordingly, ID number 914 of 2026 is hereby dismissed. कितना दिन लगेगा आपका एफिडेविट फाइल करने में?
Your Lordship, by tomorrow I will file it.
Okay. The council and the learned counsel for the Union of India has submitted that the required affidavit will be filed by tomorrow.
Yes, Your Lordship.
It is observed that there is no impediment on the part of the petitioner to take steps in connection with the offered amount of fees 34 lakhs, which may be permissible as per law.
Yes.
Right? Come at the point. If she files an affidavit, you need to file a rejoinder on that.
Lord, any day after 2 weeks, my lord, as your lordship.
Post 180?
My lord.
स्टेट को भी बोलिएगा क्या 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 प्रोसीजर हुआ है कर दी
Yes, yes.